All right. Good afternoon, everyone. My name is Mackenzie Holden. I am with the Indiana Civil Rights Commission as the Communications Manager. I'm pleased to be your moderator this afternoon. Thank you, everyone, for joining us as we host our first virtual presentation. I'd like to thank all of our presenters today, who you can see on the screen. There we go. Have all the presenters on the screen. Caroline Riker will be presenting an agency overview for the Indiana Civil Rights Commission, as well as a quick discussion over COVID-19 related fair housing issues. Tim Schultz with ICRC will briefly cover the governor's executive order, and Mark Nealon with IHCDA will cover resources and guides available for all Hoosiers through IHCDA and the Indiana Foreclosure Prevention Network. During the presentation, we welcome all questions in our Q&A box at the right hand of your screen. If you don't already see the Q&A box, you might have to select the little button that has a question mark on it so that you can view that. You may type your name, or you can leave it as anonymous and then type your question right below the name box. Questions are going to be monitored and answered when possible during the presentation. However, if your question is not answered right away, we will address every single question in order at the end of the presentation. If your question is specific toward a topic or a speaker, we ask that you address the name of the speaker in the question, which will help allow things to run a little smoother during the Q&A session at the end of the presentations. If you experience any technical issues during the presentation, no worries. You should be able to join right back in through the original link. And if you have to leave the session early, we will have a recording of the entire session available to you all to view and share with your colleagues and friends on our website. We will also share the link on our social media at IN Civil Rights, or on our website at www.in.gov/ICRC. Thank you all again for joining us this afternoon, and I'd like to go ahead and introduce ICRC's Executive Director, Greg Wilson, to share a few remarks before we get our presenters going. So, Greg Wilson.
Thank you, Mackenzie. Thank you.
Good
afternoon. Good afternoon and welcome. My name is Greg Wilson, Senior. I am the Executive Director of Indiana Civil Rights Commission. Today, ICRC is hosting our first of many live stream virtual presentations in an effort to continue our mission of serving all Hoosiers, especially during these trying times. ICRC has partnered with Indiana Foreclosure Prevention Network and the Indiana Hoosier Housing and Community Development Authority to provide informational resources to help you, whether you're a renter, homeowner, landlord, or housing employee or employer. In addition, today's panel discussion will feature experts in Indiana housing law and focus on resources and mortgage payment assistance available, as well as current coronavirus eviction and foreclosure resource guide recently developed to help all Hoosiers as we deal with these harsh times because of COVID-19. We look forward to future presentations like this, and we thank you all for attending. At this time, I would like to turn it over to our first presenter, Caroline Riker, Indiana Civil Rights Commission Administrative Law Judge. Again, thank you.
Good afternoon, everyone. My name is Caroline Stevens Riker, and I'm the Administrative Law Judge with the Indiana Civil Rights Commission. Today, I'm going to be talking to you about fair housing, as well as the Indiana Civil Rights Commission's role in enforcing those fair housing laws. Given the public health crisis today, I am going to be focusing possible hypothetical situations with respect to housing discrimination on COVID-19 and how those two different categories may actually interact.
Caroline, you muted. You might have to start. Oh, there you go.
Okay. I apologize. Just a few disclaimers. I'll go back over those. This policy, this training is not intended as legal advice or the policy of the Indiana Civil Rights Commission. If you do have specific concerns about facts related to you or someone else, please contact an attorney, but this presentation is really just intended as general legal guidance. Just a reminder, as we move through today's presentation, there is the question and answer feature. So if you have questions, please go ahead and put those into the chat. I'll try and get to them throughout this presentation at the end today. There are two specific goals for today's training. The first is to equip you all with the information you need to recognize housing discrimination when you see it. And then the second goal of today's presentation is to help you respond with impact. And what I mean by responding with impact is taking an action that will not only end the discrimination, but will prevent it from reoccurring in the future. In order to help you understand how the Indiana Civil Rights Commission actually goes about enforcing these laws, it's important to give you some context on what exactly the Indiana Civil Rights Commission is. The Indiana Civil Rights Commission is a state agency that has the mission of neutrally investigating complaints with the goal of eliminating discrimination based on protected classes in protected areas through the litigation of founded claims of discrimination. Now, there's a lot going on there, so I do want to break that down just a little bit. With respect to neutral investigation of complaints, this is the Indiana Civil Rights Commission's assignment of an investigator to a complaint when it's received who does not have a particular outcome in mind. They're not pro-complainant, they're not pro-respondent. They're really just trying to gather whatever information is needed to make an informed decision. At the end of an investigation, a decision is issued as to whether or not a complaint has merit, and this is called a cause finding. If the complaint is not supported, then a no cause decision is issued, but if the evidence collected during an investigation supports that complaint and that the discrimination has occurred as alleged, a cause finding is issued. And at that point, the Indiana Civil Rights Commission moves into its enforcement powers through litigating complaints either before a state court judge or before the commission itself. With respect to the protected classes and protected areas, this really has to do with the particulars of what the law protects, and I'll walk through those during today's presentation. As a state agency, the Indiana Civil Rights Commission is authorized by, of course, state law. And there are two laws in particular that the Indiana Civil Rights Commission enforces. The first is the Indiana Civil Rights Law, and this is Indiana Code 22-9-1. And this covers education, employment, credit, public accommodations, as well as real estate. And the second law is the Indiana Fair Housing Act, which is Indiana Code 22-9.5. And as its name suggests, it provides the broadest level of protection for housing as a protected area. So even though the Indiana Civil Rights Law does provide some protection for housing, today I'm going to be focusing on the Indiana Fair Housing Act. Now, the Indiana Civil Rights Commission does have a relationship to federal agencies as well, particularly the Department of Housing and Urban Development through the Fair Housing Assistance Program. This program allows complaints to be dual filed both with the Indiana Civil Rights Commission and with the federal counterpart, which in this case is HUD, provided the Indiana's state laws are substantially similar. And all that substantially similar really means is that the state law provides at least the same level of protection as the federal law, if not more. So Indiana, in most cases, does meet that standard. So how does the Indiana Civil Rights Commission actually go about enforcing the law? Well, it all starts initially in intake, where an intake specialist will help draft a complaint and get that mailed out to the individual who has filed the complaint. At that point, once a signed copy of the complaint is returned to the office, the Indiana Civil Rights Commission will assign an investigator to collect all the information needed to make an informed decision on whether or not that complaint is supported by evidence. At that point, once the investigation is actually completed, again, there'll be a cause or no cause finding issued. If that cause finding is issued, that case will go through litigation with an assigned ICRC staff attorney. Again, that can go to state court or through the administrative forum with an administrative law judge like myself, or through the commission as well. Throughout this process, the parties also have the opportunity to engage in alternative dispute resolution with the ICRC's department. And this can look like mediation or conciliation, which is really, again, just an opportunity for the parties to resolve the issue without a formal legal finding being made. Outside of enforcement, the Indiana Civil Rights Commission also has some obligations to educate and inform the public. So this is the Public Outreach and Education Department, as well as the cultural commissions that are tasked with providing education and resources to particular communities. And I'll give a special shout out to the external affairs teams for helping organize today's training. With respect to the particulars of what the Indiana Fair Housing Act protects, there are a number of protected classes, also sometimes called protected categories. These are race, color, national origin, ancestry, familial status, religion, sex, and disability. In terms of the kind of prohibited discrimination that the law prevents, there are 4 different categories. The first is direct intent discrimination. This is really overt discrimination. We know it when we see it. It's intended for the recipient to know that certain groups of people are not welcome. The second category of discrimination is disparate treatment discrimination. This is where a housing provider will treat one group of people differently than another group of people based on that protected category. So it is calling out specific groups of people, again, differently. With respect to the third kind of discrimination, which is disparate impact, this is the most subtle kind of discrimination. It's where a housing provider has a rule, policy, or practice that on its face doesn't call out a protected category or class, but it has the result of treating a protected category or class differently than other tenants. And really here we're looking at the math behind the rule. What's the actual result? And then the final and fourth kind of discrimination is no intent discrimination. This is where there's a direct violation of a legal requirement contained in the law. So a few examples of that could look like reasonable accommodation or modification denials, as well as building code violations. So what does all of this mean with respect to COVID-19? Well, there are some ways that fair housing discrimination could interact with some of the fears or assumptions that people might have about COVID-19 as it relates to certain protected categories. So one example is a landlord's refusal to rent to someone based on a fear that a particular protected category is associated with COVID-19. So the example I have for that is a landlord refuses to rent to an applicant with children because there is a fear that children might be carriers for COVID-19 or something like that. In this instance, it would be a violation of the Indiana Fair Housing Act to refuse that application because familial status discrimination does still apply. Another example deals with disparate treatment discrimination, and this example is based on discrimination concerning national origin. So the hypothetical situation involves Jane, who is an Asian American citizen of the United States. She's looking for an apartment. She finds one she likes. She's told that there are apartments available. She submits her application, and as part of her application, she submits her driver's license, which includes her photo. After she submits her paperwork, she's told that there are actually no apartments available, but her roommate, who's Caucasian, submits an application at the same time and is successful in getting an apartment and is still told that there are apartments available. So in this instance, the landlord is treating Jane differently than her roommate based on Jane's national origin. And it's important to consider with national origin discrimination that it doesn't have to be the individual's actual national origin. In this situation, Jane lives and resides in the United States, but it can be their perceived national origin as well. So when we start thinking about fears around COVID-19 and possible relationships to countries that are seeing higher rates of COVID-19, this could be a way that housing discrimination interacts with the pandemic. A third example has to do with those no intent kind of discrimination activities that I mentioned at the beginning. The example involves Tasha, who is an individual who has a disability related to her immune system. She makes a reasonable accommodation request that her landlord accept all of her mail, accept all of her packages, accept all of her groceries, wipe them off, make sure they're disinfected, and then bring them to her at her apartment. Now, in this situation, if the landlord typically does this for tenants, if they accept all their deliveries and deliver them directly to the tenant, then it might be a reasonable accommodation. But a lot of landlords don't do that. So in that instance, it would not be reasonable to go about preparing all of these incoming pieces of mail for the tenant, because it would be a change in the services that are typically offered by a landlord, as well as might cause some unsafe situations for staff members. The fourth and final example that I have of COVID-related housing discrimination deals with high-risk categories and assumptions that people might make about individuals who fall into high-risk categories as they relate to particular protected categories. So it would be housing discrimination if a landlord required all persons who are high risk to move to certain apartments or to move to certain parts of the building. In this instance, there might be a link between someone's protected category and that designation of high risk. This is an example of disparate treatment, but it's also an example of two kinds of housing discrimination, steering as well as segregation, and neither are permissible under the Indiana Federal Fair Housing Act. So as part of this conversation, I do want to bring up a few open questions and really get you thinking about how COVID-19 might have a broader impact on housing discrimination. As I've walked through this presentation, I've noted that all of the rules still apply. So fair housing law is still being enforced just as it would be even if the pandemic were not occurring. But there are some specific issues that are worth giving a second thought to. So with respect to COVID-19, there is an open question as to whether or not COVID-19 is a disability as defined by Indiana or federal law. And if it is a disability, there may be some additional concerns with respect to how the law is enforced, particularly with respect to discrimination based on association for individuals who have disabilities. Housing providers may not discriminate against people based on an association with someone who has a disability. And in this case, if COVID-19 is considered a disability, we're talking about healthcare workers or people who, as part of their profession, may come in contact with individuals who have a COVID-19 diagnosis. If COVID-19 is considered a disability, then that would fall under the category of fair housing discrimination. However, on the other side of that coin, it's important to recognize that housing providers are not required to permit or foster dangerous conditions. And what that could look like is rules or policies that are designed to keep staff members as well as tenants safe. So for example, closing down certain parts of the apartment complex, if that's a pool or a gym or a place where there's typically a lot of public activity, in order to reduce the numbers of people who are gathering in public. As long as that's not based on a protected category, it's something that applies to everyone, then that may be permissible. But it's likely that a lot of these decisions are going to be very fact-specific and very case-specific and reviewed after the fact, of course. So as these decisions are being made by landlords and by tenants, it's important to document what's going on. Why was the decision made? What was supporting it? What was against it? What was the rationale for the final decision that was made? And just to wrap up everything that I've shared, I do want to leave housing providers and tenants with a general bright line that can be used to distinguish between rules that are safe and rules that fall into housing discrimination. So of course, housing providers may enact rules that are aimed at keeping tenants and staff safe. However, housing providers may not base those rules on stereotypes about protected classes, and that includes stereotyping how an individual might be associated with COVID-19. So what do you do if you see housing discrimination in your community or you are a victim of fair housing discrimination? So you can, of course, file a complaint with the Indiana Civil Rights Commission. Right now, the Indiana Civil Rights Commission is still accepting complaints by phone. That phone number is 317-232-2600, as well as filing complaints online, and that web address is on the screen. It's important to know these complaints do have to be signed and that there are some statutes of limitations to keep in mind. The Fair Housing Act has a statute of limitations of 1 year, and the Indiana Civil Rights Law has a statute of limitations of 180 days. And there are opportunities throughout this process to get that investigation started after the complaint is filed, but also to resolve the complaint earlier through mediation or other resources like prompt adjudication. So thank you all very much for your time today. At this point, I'm going to turn it over to Deputy Director and General Counsel Tim Schultz to provide some guidance on the executive orders.
Thank you, Caroline. That was a wonderful presentation. Okay. As Caroline mentioned, my name is Tim Schultz. I am the Deputy Director and General Counsel for the Indiana Civil Rights Commission. Today I'm going to be discussing very briefly the temporary prohibition on evictions and foreclosures in the state of Indiana. This is taking us a little bit away from the fair housing laws that Caroline was discussing, but this is obviously something that's very relevant in light of current health crisis, and we thought it would be just a great opportunity to provide everyone with a little bit of information about what some of those protections are right now. As Caroline mentioned earlier, no information contained in or discussed pursuant to this presentation may be considered legal advice. If you require legal advice or guidance, please contact an attorney. Furthermore, this information may not be considered as the Indiana Civil Rights Commission's official policy, as this presentation is only intended to provide general information. Just a very quick overview of what I'll be discussing today. I'll be talking about what housing-related protections the state has invoked in light of the current health concerns, some other considerations that Indiana citizens should be taken into account regarding those protections, what to do if you experience a particular entity failing to adhere to those temporary housing protections, and also I'll briefly highlight some additional resources that I encourage everyone to explore further. So first, I'd like to mention Executive Order 20-05. This order was issued March 19th, and it is currently effective until May 5th of this year, unless extended by further executive action. What this order does is it designates certain services as essential services, specifically gas and electric utilities, broadband, telecommunications, water and wastewater services, and prohibits providers of those services from discontinuing those services while the order is in effect. So obviously, if you're staying at home, ensuring that you continue to have access to utilities is very important for your health and welfare, and that order addresses that. That brings me to Executive Order 20-06, also issued March 19th and effective until May 5th of this year, unless extended by executive action. The order temporarily suspended the initiation of housing, eviction, or foreclosure actions. The order applies to residential real estate or property, whether rental or otherwise. And while the order suspends the initiation of eviction and foreclosure actions, I think it's very important to highlight the fact that the order also states that it cannot be construed as relieving any individual of their obligations to pay rent or make mortgage payments or otherwise comply with obligations of their tenancy or mortgage. So while there's a suspension of the eviction or foreclosure actions, you are still responsible for all of your obligations relating to your mortgage or lease. So that brings me to the other considerations that I think people should be considering if you are relying on these temporary state protections. So what happens when the executive orders expire? Executive orders will expire. As I noted before, these two orders I've summarized expire May 5th of this year, and that's extended by executive action. Well, the first thing that can happen is that once those orders expire, then eviction and foreclosure actions can be initiated by lenders or landlords. Another thing to take into account is that once those orders expire, a landlord or lender may now request that you pay any outstanding liabilities you have on your lease or mortgage. As I mentioned before, the executive order clearly states that it's not relieving you of your financial obligations. It merely is intended to suspend foreclosure and eviction action. Another thing to be mindful of, I think, here is that a lender or landlord may also attempt to apply late fees or penalties to any missed payments. Whether or not those are appropriate may depend if you qualify for certain other protections from any other programs that are operated at the state or federal level. But I think the most important thing I can reiterate, if you're having difficulty with these payments, is don't wait. Contact your landlord, contact your lender, and if you're having difficulty, start working with them now so that you're not surprised by whatever action they may take after the executive orders expire. Because remember, these orders will expire at some point. That brings me to the next consideration. What if you were subject to an eviction or foreclosure action that was initiated before the executive orders took effect? I think it's very important to note that the executive orders are silent on any previously initiated action. So I think no one should assume that those executive orders apply retroactively. There's no language in the executive orders that suggests that they do. And with that in mind, it could be appropriate for those actions to continue going forward even while the executive orders are in place. So bringing it back to what I said before, you should be contacting your landlord, contacting your lenders if you were subject to a foreclosure or eviction action prior to the executive orders. Don't just wait. Don't assume that the executive orders apply. Be contacting those lenders and landlords and find out what the expectations are. That brings me to my next point. What if you experience an entity that you believe is violating the executive orders? What has happened is the Indiana Attorney General's office has updated its website to accept consumer complaints relating to those potential violations. The website here is listed. I won't list the entire thing, it's rather lengthy, but it allows you to submit a consumer complaint online, or you can request a complaint form by calling in. Again, the number is listed here on the screen, and those complaints will be reviewed by the Attorney General's office, and whatever action is deemed appropriate by the Attorney General's office will be taken. But they have updated their website to account for matters related to the violations of these executive orders to ensure that they are being enforced when possible. Finally, that brings me to some additional resources. As Caroline noted, the Indiana Civil Rights Commission is still up and running. We are still accepting complaints. We are accepting inquiries. If you have any concerns that you have, experienced a discriminatory practice, please call us or contact us on our website. Again, our website is listed there on the screen. And even if you're not sure, if you've experienced a discriminatory act, or you think it might be related to current health concerns, or even if you think it might be something to do with the executive orders that I've mentioned, you can always call us and we will give you the information that you need to either maybe work with another agency or maybe continue to work with us if appropriate. The other thing I'd like to highlight here, there's been a number of federal programs, protections created by recent federal legislation that I don't want to go into here, but those programs you may qualify for certain protections, and I think if you have any questions or concerns or just inquiries about whether or not you may qualify, I would suggest contacting a HUD-approved housing counseling agency in Indiana. And that's the second bullet point on the screen now. It's a rather lengthy website address, so I won't read it off, and I'll give you a moment to jot it down if you like. Also, I'd like to note that the Indiana Housing and Community Development Authority has created and published a coronavirus eviction and foreclosure prevention guide available on their website. I won't go into that because the next speaker is going to. But I just think that it's a great resource. So I just wanted to mention it. And then our next speaker will also be discussing the Indiana Foreclosure Prevention Network resources. Again, I don't want to go into that because he's going to cover that. But yeah, so with that, I will conclude my presentation. I think we've got a couple of questions. I'll let Mackenzie go through those, and I'm sure we'll have some time at the end of this presentation to discuss. But with that, I will turn this over to the next speaker.
Good afternoon, everyone. My name is Mark Nealand. I am Director of Asset Preservation with the Indiana Housing and Community Development Authority. I oversee the Indiana Foreclosure Prevention Network and our flagship program, the Indiana's Hardest Hit Fund. I'll tell you a little bit about the Indiana Foreclosure Prevention Network. IFPN was created about 12 or 13 years ago by the Indiana legislature to help Hoosier homeowners avoid foreclosure. It was prevented sort of right at the beginning of the last housing crisis that many of you may remember that began late 2007 and really started to hit hard in 2008. We provide free foreclosure prevention counseling. We have a network of housing counseling agencies, all of whom are HUD certified or affiliated with HUD certified agencies. And as I mentioned, we have our flagship program is the Indiana Hardest Hit Fund. The Indiana Hardest Hit Fund was something created by the U.S. Department of Treasury in response to the last economic crisis. And many of you may be surprised to learn that HHF, those are actually TARP funds. So this funding is something that Indiana has actually had for quite some time. We began first providing assistance in 2011 and have been providing mortgage payment assistance since then. To date, we've helped over 10,800 homeowners and provided more than $170 million in mortgage payment assistance. We do have some limited funding available remaining that we have redirected to help us with this coronavirus epidemic. So let's talk a little bit about what types of assistance we have. There are two types of assistance that we'll have available to homeowners. One is called reinstatement only assistance. This assistance is for individuals who can afford to make their monthly mortgage payment moving forward, but they may have gotten behind for one reason or another. They may have been laid off from a job and were out of work for 3 or 4 months, got behind on their mortgage payment then. They've been fortunate enough to go back to work now. They can make their mortgage payment next month, but they don't have $4,000 or $5,000 that their lender wants for the months that they miss. In those situations, we can come in and make a payment on behalf of the homeowner directly to the lender to bring them current and then allow them to make their payments moving forward. The hardships are listed on the screen. So any involuntary financial hardship related to unemployment, underemployment, a medical hardship, for some reason you had a heart attack or something like that, and you're in a position or you were put in a position to, where you had to figure out, do I pay these medical bills or do I make my mortgage payment? Those are situations where once you've gotten back on your feet, we can come in and help cure that mortgage delinquency. Death of a contributing household member, you lost that income from a contributing household member and now you're struggling because of a death, again, that is something that we could provide assistance for to qualifying homeowners. And also divorce. The maximum allowable household assistance is $30,000, and it is a one-time payment to the lender. We make those payments directly to the lender on the homeowner's behalf. No money is actually sent directly to the homeowner. Now, the monthly assistance program, and this is a program that we were operating. We operated up until about 2017 as we navigated through that last economic crisis. As some of you may recall, Indiana's unemployment rate hit roughly 10% across the state during that last economic crisis. And so we had a program then to provide temporary mortgage payment assistance on a monthly basis while homeowners were unemployed and seeking to find new employment. As the unemployment rate fell, we shifted more toward that reinstatement only assistance that I mentioned in the last slide. Well, obviously with this COVID-19 pandemic and the stay-at-home orders and the social distancing, all of the business closures, we're seeing people laid off and furloughed. So we decided we needed to bring that monthly assistance program back. So what we can do is for homeowners who have experienced an involuntary financial hardship on or after January 1, 2020, we can provide up to 6 months of monthly mortgage payment assistance. You don't have to be behind on your mortgage. So if you've paid your mortgage up through the end of April, but you just found out you've gotten laid off, you're not going to be able to make your mortgage payment in May, that's fine. You don't have to be behind. We can, once we get you approved, we can start taking over making those payments. Now, the next bullet point can be a bit confusing. We say the homeowner cannot be in an active forbearance. And what is a forbearance? So a forbearance is if you go to your lender and tell them, hey, I've been laid off, I'm affected by COVID-19, could you temporarily suspend payments? And I believe Tim talked about this a little bit in his presentation. It's where your lender temporarily suspends your payments. You don't have to make your payments, but unfortunately, that debt will accrue. They don't completely forgive those payments, but they just put them on hold. You don't have to make them on a monthly basis. The reason we say that you cannot be in an active forbearance is that for some lenders, and we have more than 300 lenders signed on to participate in this program statewide. Some lenders, if you are in an active forbearance, they will object to you receiving hardest hit fund, or they will make you make a choice between the forbearance or hardest hit fund. So I don't want anyone to be confused and think that they cannot apply if they are in an active forbearance. It just may simply, if you're in an active forbearance, it may delay what we might be able to do with hardest hit fund. The other requirement is that you have applied for or are receiving unemployment assistance benefits. This is sort of our default determination to identify that you've had an involuntary employment-related financial hardship. If you're getting unemployment benefits through the Department of Workforce Development, we know automatically, okay, you have a hardship that qualifies for the program, and then we would move on to some of the other eligibility criteria to determine whether or not we could provide you the assistance. Again, the available assistance is $30,000, and we make those payments directly to the lender. Basic eligibility criteria: you have to be an Indiana homeowner, you own only one mortgaged home and reside in that home as your primary residence. The reason I say only one mortgaged home is that we will not deny anyone assistance if you inherited a home from your grandparents and that home is completely paid off. You're not making mortgage payments on it. It's not your vacation rental property in Hawaii. It's just something that's in your family. We don't want to deny anyone assistance for that. But if you do have another mortgage on another property, you won't be able to take advantage of the assistance from this program. And there are some federal guidelines behind that I won't go into. Again, for monthly assistance, you're unable to make that monthly mortgage payment because you have an involuntary employment-related financial hardship, such as a job layoff. Or for the reinstatement-only program, you can make your monthly mortgage payment, but you're unable to pay that past due balance that resulted from a previous hardship. There are some additional eligibility requirements, but my advice to you is go to the website. If you're a homeowner and you need assistance, apply online. You will then be referred to one of our network housing counselors, and our housing counselors can work with you, take you through the rest of the eligibility guidelines, make sure you qualify, help you gather all the information and documentation that you would need to apply. And you see there on the screen, you see the web link. It's 877gethope.org. And you see a little screenshot of what the screen will look like. Now, before I move on to additional resources, I do want to explain a little bit further about what Hardest Hit Fund is, because I know on the surface it sounds way too good to be true, but it is true. There are, however, some catches. The catch is this is a loan program, but it is a forgivable loan program. By forgivable, I mean if you stay in the home for 10 years, the loan is completely forgiven. If you sell the home before that 10-year period, it's only repayable to the extent that you make a profit from selling your home. So if you were to come in, be approved for Hardest Hit Fund assistance, receive $30,000 in assistance today, and then next year you go to sell your home, but you only make $100 in profit from selling your home, you would pay us back $100 and we would forgive $29,900. In addition to that, the mortgage or the loan, we start to forgive that loan in year 5. We start to forgive it at 20% per year. So as soon as you've completed 5 years, as soon as you start year 6, we knock off 20% of the balance, and we knock off an additional 20% each year until it's completely forgiven. Now, again, it is only repayable to the extent that there are net proceeds from the sale of your house. So if you break even, you don't have to pay us anything back. And I'm sure we'll have some questions on that, and I'll be happy to take those in a few minutes. Let me move on to additional resources. As Tim mentioned, we have created, IHCDA has created some additional resources to help you navigate this very confusing and very troubling time. Several state organizations work together to come up with some frequently, or to provide answers to some frequently asked questions. And I don't know, I'm going to see if I could hover over this. Hopefully you can see the link there as I hover over. But this is the Eviction and Resource Guide. There you see the web link to it. Indiana Legal Services has developed a resource guide for renters, and I'll hover over this link. IHCDA has an energy assistance program, so if you're having trouble paying utility bills, here's a link to that. And this presentation, I believe Mackenzie will be sending this presentation out after today, and these links should be live in this presentation when you get to them. The township trustees, there are another resource that provide a variety of services for both renters and homeowners, and you see the link there. Indiana Housing Now, and let me see if I can, is yet another resource. This is for renters and property managers. It offers a variety of housing resources, links, information for you. And then one additional slide. Again, the Eviction and Foreclosure Resource Guide. I think I got that one on there twice, so we really want you to go take a look at that. Hardest Hit Fund, again, 877gethope.org. I know that one by heart. And again, energy assistance. And then I'll be available for questions. With that, I will turn it back over to Mackenzie.
All right, thank you so much, Mark and Caroline and Tim, for going over everything. We do have quite a bit of questions in the Q&A. If you have any questions and you have not submitted any questions yet, no worries. You still have, we have 12 minutes to go over any question and answers. So I will go ahead. We have a question in here to provide additional information regarding how COVID-19 is a potential disability under ADA. So I'm going to let Caroline go back over that one. So feel free to go ahead, Caroline.
Okay, so I'm going to share a little bit more information about that. And although the question is phrased about the ADA, I'm going to reframe that a little bit to talk about fair housing, because there are specific administrative codes that cover how disability is defined, particularly within the state of Indiana. So this is the code provision up on the screen, 910 IAC 2-3-2. And on the left side of your screen, you've got the actual citation from the law. A disability is a physical or mental impairment which substantially limits one or more major life activities. And I'm going to be focusing on that first definition here. And on the other side of your screen, you've got some information about what particular functions could be affected by COVID-19. So whether or not something is a disorder, one of the requirements is that it affects the major body system, which in this case would be the respiratory system. And then a major life activity, one example from the code is breathing. And so that's where COVID-19 could again be relevant. So with respect to whether or not COVID-19 rises to the level of disability, we're really focusing on substantially limits. And right now that's the open part of the question, is to what extent is COVID-19 something that substantially limits these parts of living, right? Because breathing is really something that is essential. So some examples you can look to in case law is whether or not asthma rises to the level of disability. In some cases it can. Same with other systemic diseases like AIDS or HIV. Those can, in certain instances, rise to the level of disability. So it's not really an all or nothing. It could be somewhere in the middle. And then with respect to one of the other questions that I saw in the chat concerning, are you allowed as a landlord to ask about whether or not someone has tested positive for COVID-19? And this really gets back to that question of whether or not COVID-19 is a disability. If it is, then that may not be something that can be asked. If it's not, then it's possible that that question could be asked. But really, at this point, it may be better off for housing providers to try and control that through safety rules, like I touched on, so limiting congregation in public areas or things like that, as opposed to actually asking someone for symptoms or positive tests, because even in those situations, asking someone something about symptoms to COVID-19 could even bleed into symptoms of someone else, a different disability, and there again you've wound up in an impermissible space. So landlords really have to be very careful about what they're asking for, and it may be better to land on the side of safety rules that are applied generally and without, again, no stereotypes, than actually asking questions about someone's status. And at this point, I'm going to stop sharing that screen. Thank you, Mackenzie.
Absolutely, yes. So let me pull this back up. Okay, thank you, Caroline, for that explanation. Let's see here. We have quite a few, so give me just a moment to scroll back up here. I did a couple questions that are coming up. All of the entire session will be recorded, is being recorded right now and will be posted on our website. I've posted at the very end, I'll show that screen with the link to our website. It's also in the question and answer portion. And the link to that page will also be shared on our social media shortly after this presentation ends. And our social media is at IN Civil Rights, or you can just search Indiana Civil Rights Commission. So let's see what we have next. So we have a question regarding rental assistance funds for tenants. And I think that might be something Mark can respond to.
Yes. At this time, IHCDA does not have a large pool of funding for rental assistance. There was some very limited funding that was provided in the first round of the CARES Act to provide some assistance for homelessness prevention, housing of persons with HIV, and a few other things, but that money was very limited. We are hopeful, and there is some legislation pending in the United States Congress now that would, if passed, provide additional funding to state housing finance agencies to provide both rental assistance and homeowner assistance. But unfortunately for rental assistance, that funding has not yet been made available by the federal government. With respect to, again, homeowner assistance, because we already had an allocation of funding from the federal government that was here and in existence, we were able to pretty quickly pivot and make that funding available to homeowners. Unfortunately, federal regulations limit our ability to use that funding to only use it for homeowner assistance at this time.
All right, thank you, Mark. Hopefully that answered that question. Let me see. I think you might be able to answer the one right below that as well. For a phone number to call for free consulting regarding foreclosure. That would be the IFPN, correct, Mark?
Yes, there is a number, but my advice to you would be to go to the website, 877gethope.org, click apply, and be assigned to a housing counseling agency. Work with a certified housing counselor that can help you take you through all of your options. The call volume that we are getting at this time really limits our ability to give or to spend a lot of time on the phone with homeowners discussing all of these options. Our call volume is simply, it's been astronomical in the last week. And so my advice to you would be to go to the website, click on the FAQ link. There's an FAQ link at the top of the page that explains a lot about the program. Then if you still have questions there, or if you think the assistance is for you, click apply. We'll get you to a housing counseling agency who can work with you through all of those options and explain things in more detail to you.
All righty, thank you, Mark, for that one again. I think we have, so the next one is, are there any indications that the governor's May 5th executive order will be extended, which is what Tim covered during the presentation? I'm not sure if he can give an exact answer to that, but do you have a comment on that, Tim?
My only comment is that we do not have a comment. That is purely at the discretion of the governor's office, and we are not a party to that process.
Okay, alrighty, thank you. Another one we have, it says Indiana Supreme Court published a letter after the governor's order stating a landlord can still file before the emergency order is lifted, and asked if we had a comment on that.
So again, going back to my disclaimer, none of this is considered to be legal advice. That being said, obviously, nothing that's been said by anybody today should be construed to contradict anything that's been issued either from the governor's office or the Indiana Supreme Court. Please just review those resources, and if you have questions, I would seek information from the appropriate authorities.
Okay, all righty, thank you, Tim. All righty, so I believe that's all of the questions in the question area. I've listed on the screen right now our website link as well as our social media, where those links with this presentation will be posted here shortly after the presentation ends. If you have any other questions, if you could please send them to my email listed above, and I will make sure that those get sent to the appropriate presenter, and hopefully we can get you those questions answered. I think that is all that we have for today. Again, I want to thank you to all of our presenters who participated today, as well as all of our attendees. This is our first virtual educational presentation, and it is definitely not going to be our last. So we ask that you still you reach out and follow us on our social media, on IN Civil Rights, keep up with our website for updates, and hopefully you will be attending more events like this in the future for us. So thank you again, everybody. Thank you, Tim, Caroline, and Mark for presenting, and hope everybody stays